I will have the pleasure of chairing this first panel of our discussion on the digital fitness check. And I have with me on the panel 4 distinguished experts, so I will start with introducing them. On my right, we have Ursula Pachel, who is Deputy Director of BEUC, the European Consumer Organization. Also on my right, we have Jelle van Loo, who is Inspector Coordinator at the Director General for Economic Inspection of Belgium. And on my left, we have Peter Roth, who is Professor at the University of Oldenburg in Germany. And finally, Jolanda Girdl, who is Senior Policy Counsel of the Swedish Commerce Association. And today, here she represents the E-Commerce Europe Association. So as you see from the agenda for the second part of the event, we will be tackling 2 topics, starting with burden of proof, followed by questions on addictive design and use of digital services. These topics are being discussed in the framework of the Commission's ongoing evaluation of consumer legislation, evaluating the fitness of the current rules to address the new and emerging problems in the consumer area. Commission has been running this exercise already since last year. We have held several events, and you have also probably been involved in different surveys as well that have been posted since last year. But for this event, we decided to choose these 2 more concrete topics because they are very important. So even though consumer law is very much about substantive rights, but there is always a very important element of enforcement. So, for example, during the last review of consumer legislation in 2018-19, we tackled many different substantive aspects of consumer rights, but we also paid close attention to improving enforcement. Thus, for example, we strengthened the rules on penalties, introducing fines for the cross-border infringements of consumer legislation. We also enacted a specific right of redress for victims of unfair commercial practices. And finally, of course, we proposed, and it was later adopted, a new directive on representative actions for the protection of collective consumer interests. So the so-called collective redress directive has been enacted. So as far as this current exercise is concerned, we would like to pay particular attention to the topic of burden of proof, because it's very important for the practical enforcement of the legislation. And that's why we have invited these experts today to this panel, so that they can give their perspective from the different viewpoints: consumer protection, enforcement, academia, business organization on this subject. So I'd like to welcome them. I also welcome you, and of course I welcome all the numerous people who are following this event online. This is primarily an online event. And we have quite a number of registered participants who are following us online. And to those participants in particular, I would like to ask you to not to hesitate to put your questions in Slido. You have seen the code. It is ADCE23. And so we welcome your questions and comments on the subject that the experts can afterwards discuss. But now I would like to give the floor to our first speaker, to Ursula, who is going to tell us what are the challenges related to burden of proof for consumer protection in the digital environment. So, Ursula, please, the floor is yours.
Thank you very much, Martins, and good morning, everybody. Thank you again to DG Justice for organizing this and for putting this very pertinent topic up front on the agenda of the Digital Consumer Summit, the reversal of the burden of proof. Next slide. So I will start maybe just setting a little bit the scene as I'm the first speaker, just to start with the basics. The basic rule in private law, as I think you know, is that the burden of proof for a claim rests on the party that is making that claim. And in consumer protection law, very obviously, this is then very often the consumer. In asymmetrical situations between the parties, we already have adjustments of these basic rules. There are reversals of the burden of proof. There is also alleviations, for example, documentation duties or disclosure duties, for example, in anti-discrimination law, in product liability legislation, in sales law, etc. And I would like to underline that the important element of the 5 mandatory categories of the fitness checks of the European Commission, and the first one on the list of the 5 elements is effectiveness. Effectiveness, the principle of effectiveness has already has been established by the European Court of Justice. When it comes to enforcement, we have settled case law that shows that rules for enforcement of individual rights cannot render it effectively impossible to obtain reparation. So this is really a well-established principle, and I would like to say that in a fitness check, as effectiveness is so important in the evaluation, the burden of proof really lies, I would say, at the heart of the current fitness check on digital fairness. And the digital market, as we know, creates, we say, unprecedented asymmetries of knowledge and of power between consumers and traders. In research and academic work, this has been called the typical digital asymmetry, where the weaker party has no way of proving their case because the trader holds all the cards, the knowledge about the products and services, the algorithmic systems that are used for the decision making, the control over the choice environment, if you think about the interface design, etc. So the complexity of the technology is making it very difficult for consumers to understand what the trader is really doing behind the scenes. Next slide, please. In a nutshell, for consumers and for the representatives of consumers, like consumer organizations, the exercising of their rights in the digital world and thus the burden of proof is a really crucial element. And the Unfair Commercial Practices Directives framework, we think, should be updated to remedy this imbalance and to preserve the effectiveness of the law. There is already a specific article in the UCPD about evidence. It is basically obliging the member states to empower the courts or the administrative authorities to enable them to require the trader to provide evidence to substantiate claims. But this is something which is optional, obviously, then to happen or not, and we think it is not enough. And just to mention that the burden of proof discussion and the relevance of it also applies beyond unfair practices law. As I said, it's also an element and needs to be looked at in the sales of goods directives, product liability directive, etc. Next slide, please. Just to put a little bit of context into this discussion, exercising consumer rights in the digital environment, why is this not easy? First of all, because of this information asymmetry. So how do you understand as a consumer information about products and services which are so complex due to the use of technology? How can you explain, even for a trader it's difficult, in plain and intelligible language, how an AI system works in a product? This is why we think that informed decision-making is becoming increasingly difficult, and this is why we think consumers must be protected by design and by default. Consumers deal with technology and services that are black boxes. You don't know what is going on behind the scenes, and the increase in personalization also makes that consumers don't have a reference point. They don't even know what offers their neighbor or their friends see. They don't even know in price personalization what prices are required from other consumers, and this is a gap that we expect only to grow. And also an important element in this discussion is to know that consumers do often not complain because they just don't see a point in complaining. The low chances of success and the length of proceedings are two important reasons that consumers mentioned in a survey that we did this year. So 61% of consumers said that they think because of the low chances of success, it doesn't make a lot of sense to complain. And maybe just to give two concrete examples for concluding the first part of my presentation, if you think about dark patterns, next slide please. You're going through a website, you're going through a clicking stream, which is maybe changing according to the choices you make. When you go through the flow, you will end up with a specific situation, a paradox if you want. If you were tricked and you continued clicking, you don't have a proof, and it will be very difficult to replicate what has happened on that website. And if you did not fall for the trick, you will not have a case because you will not have made a transactional decision. So this is one of the specific difficulty in this situation. Or if you think of behavioral price personalization, where prices are based on your online behavior, where there may be a specific profile, then you will have no idea whether, first of all, the algorithmic system was the reason or was applied for the price personalization. This should now normally be disclosed, but still you will not know what were the criteria for it and what was behind it, or was it an assessment of your willingness to pay or not. I will stop here for the first round of presentation. Thank you, Martins.
Many thanks, Ursula, for setting the scene and for explaining the challenges for consumers. Indeed, these are related to the asymmetry of knowledge and of information between the traders and and consumers, which clearly becomes even more pronounced when more advanced technologies are put to use for marketing products and services. I would now like to turn to our expert Jelle, who works in the Belgian Public Enforcement Authority. And I would like to ask you, Jelle, to explain what burden of proof requirements mean more practically for effective public enforcement and how these are addressed in Belgian legislation.
So thank you. Next slide, please. So, as Ursula stated, the basis for the Unfair Commercial Practices Directive at the moment is Article 12, which states that we can require traders to furnish evidence on the accuracy of their factual claims related to a commercial practice. If a company states, for example, we have it a lot in greenwashing cases, that they have a very green product, it's 5% better now or 50% better than competitors, then we can ask them to furnish evidence about it. They need to prove it. So that's the reversal of the burden of proof currently for misleading claims. We can only ask this, as said Ursula, if it appears appropriate on basis of the circumstances of the case. So this is a bit of a proportionality test between consumers, the interest of consumers, and the interests of businesses. But still, it's not a silver bullet. But then we get, for example, for greenwashing, a lot of evidence, studies, and then we still need to investigate these. So we still need a lot of resources, personnel, to come to a conclusion. Is it a misleading claim or not? So it helps us, but it's not going to solve the case directly. So next slide, please. Then in Belgium, we also have some specific legislation on the burden of proof. For example, the CPC regulation on the cooperation between European consumer authorities states that there is a minimum power for the inspection, study and disassemblishment or testing of certain goods and services. But it remains very difficult. Yeah, we can't disassemble a good ourselves. We are not technical experts. So in Belgian law, we added the principle that, again, if there are sufficient indications that there's something wrong, that there's an unfair trade practices, and we don't have the knowledge or the ability to carry out the inspection ourselves, that we can ask or order the company to submit the goods for dissection or inspection to an independent laboratory or a research institution so that can do the tests for us at the company expense. Again, there's a proportionality test only when we have certain indications that there's something wrong. And then finally, we have a specific rule on the burden of proof of our factual observations. When we go to a company, for example, checking the energy labeling in an electronics store, then afterwards the trader can't discuss, like, yeah, it's not true what you saw there. We have a rule that says that all observations of our agents should be deemed conclusive until proven otherwise by the trader. It's to avoid discussions on factual observations and only go on a discussion on the infringement, possibly. Next slide, please. And then finally, something I always think about immediately on the burden of proof would be the new rules on legal guarantee, because there you have exactly the principle of the switching of the burden of proof for a consumer towards a trader. There's a minimum of 2 years for European consumers for the legal guarantee when buying new goods. In the old situation, on the old guarantees directive, the first 6 months, the burden of proof was on the trader. First 6 months it was on the trader, and then only for the 1.5 years afterwards, the burden of proof was on the consumer. Now, since the 1st of January 2022, this has switched. So the first year, it's now the burden of proof on the trader, and the second year, the burden of proof is on the consumer. This is minimum harmonization, so member states can go further. And in Belgium, we have said that the burden of proof remains with the trader throughout the entire 2 years, because for the consumer, it's very difficult to prove that the product went defect because of his mistake, or if the defect was already there in the product when he bought it. So these are some elements in current legislation that I would think about for the current enforcement of consumer law.
Thanks a lot, Jelle. Indeed, we do have certain provisions tackling burden of proof issues in the European directives, and you also mentioned the national rules, procedural rules regarding the authoritative force, for example, of the findings of the public enforcement authorities, or the obligation for traders to submit to checks by independent laboratories and experts. These are all very, very pertinent for our discussion. I would now like to turn to Peter and ask you, Peter, to tell us more broadly about how the matter of burden of proof is tackled in consumer law, but also in other areas which are close to consumer legislation, from which we could potentially draw some lessons and inspiration.
Well, thank you very much for the opportunity to speak here. And go straight to the second slide, basically. Ursula already mentioned the Court of Justice, and us academics always love to start from there. She mentioned the general principle of effectiveness and its effect on the burden of proof, and I would like to go a bit deeper into that. If you go to the next slide, please. Thanks. So one of the leading cases, of course, is the case of Danfoss, and it's an old case on the equal pay for men and women, decided already in 1989, and it was in principle a very simple case. The women found out that all the male employees earn more than them, but they couldn't get an explanation for that, because there may be different reasons for that. It could be that the males have all been in the company for 25 years and the women just started, or whatever. It was impossible for them to find out. So the Court of Justice turned the burden of proof, reversed the burden of proof, and asked the trader to give information on why that is the case, so that there can be an assessment on whether it's discriminatory or not. A much more recent one is a consumer credit case of CR, consumer finance. The question was simply, well, a consumer who was close to bankruptcy got a credit. The question was whether the creditor had actually performed the creditworthiness assessment, as they have to do under the Consumer Credit Directive. Now, how can you know whether the creditor has done that? It's only the creditor who has that information. So the Court of Justice said, well, it's impossible for the consumer to understand, and the creditor has to lay it open. A third argument, or third reason where the consumer is lost, is where there is simply no technical expertise in place. And this is basically the reason of why the burden of proof is reversed in the Sale of Goods Directive for the first 1 year, and why there is such a proposal in the Product Liability for the new product liability directive. Can you go to the next slide? Thanks. So basically, if we look at reasons, or if we look at these reasons and look at digitalization, we can see that the situations are quite similar. Sometimes there is simply lack of transparency. You can see something, you can see different prices at different times, but you don't have an explanation for that. And there could be different explanations. The only one who has the explanation is the trader. And this is complemented by the lack of technical expertise. Consumers and even consumer organizations, and I understand to some extent even consumer authorities, lack the technical expertise to understand why or how a specific algorithm works. They are not able to reverse engineer to try and find out. I've seen huge studies by academics trying to understand why a website reacts like this or like that. This is impossible. So the only one who can understand and can explain is the trader. Next slide, please. Now, the burden of proof discussion is always a bit sort of straight in saying, well, it's on the one or it's on the other side. But that's not the case. There are quite different types of alleviations and reasons or situations in which the burden of proof is reversed, and in which or what kind of alleviation the claimant may get. So where the system is transparent, information and explanation is the way forward, as in the case of Danfoss in the equal pay for men and women. Where only the trader has access to relevant information, it's of course on the trader to show that information. Where the trader then does not do so, the only possible consequence is really that there's a presumption of a breach, because what else can you do? Very often, the trader will then have to support information by sort of evidence documentation. And the Court of Justice in SEA Consumer Finance made it very clear that a diligent creditor, of course, has documentation of the creditworthiness assessment. That's what a diligent trader has to do. So there must be documentation done. In the proposed product liability directive, we see other grounds, like we have a proposed reversal of the burden of proof where the indication of a breach is particularly strong, so where it's sort of like here for an obvious malfunction. And we have a similar rule in German law, medical malpractice law, for example. Like if you have surgery on the wrong leg, it's a pretty strong indication that there was negligence on the other side. Or finally, and this again applies to digitalization, where the claimant faces excessive difficulties due to technical or scientific complexity. The standard of proof, not the burden of proof would be reversed, but the standard of proof could be lowered. So you don't have to show that there is certainty between this and that, but it's more likely than not that this was the reason. So there's a whole range of measures that you could take to help the claimant. I'll leave it at that for the moment. Thank you.
Okay. Thank you, Peter. Well, indeed, we could see from your overviews that there are different solutions possible and different approaches, and in particular, the product liability directive that you mentioned is currently being negotiated, and probably it will be adopted quite soon, and so the solution that will be found for the product liability claims could be also an interesting one to consider for the possible future revision of EU consumer legislation on this matter. But now, to complete this first round of interventions, I'm turning to Yolanda, and I would like to ask Yolanda what burden of proof would mean for businesses, and in particular also for helping to ensure that there are equal opportunities between businesses, a so-called level playing field. So how could a more effective enforcement would actually help those companies that are more diligent in complying with the law? Thank you.
So, thank you so much for the invitation. It's a pleasure to be here. Well, I would like to start here with a phrase that we often hear when we are talking about consumer law, and it is that the EU consumers are the best protected consumers in the world. And it is very important to strike the right balance between consumer protection and the legal certainty. Sorry, new slides. Yes. What we always are talking about is the Unfair Commercial Practices Directive and the Consumer Rights Directive, and they ensure that consumers benefit from a high level of protection in cases that they receive also compensation when that happens. And it was nice to hear we also talked about the improvement of, for example, the shifted burden of proof. Here we could hear that it has added, I can say for in Sweden, we have 2 years of shifted burden of proof and 3 years of legal guarantee. So you can see that it differs a lot within the EU. But also, thanks to the current issues of burden of proof, traders can provide appropriate compensation to legitimate claimants. And of course, it's in their interest to build consumer confidence. We are talking about trust when you are shopping, and you would like to have good relations with consumers, because if they are happy, they will shop, and it's a mutual agreement there to act as good as possible. We also have the kind of additional now legislation that are aiming to place heavier obligation on traders. But this legislation must go hand in hand when you have the reflection of enforcement and administrative costs for businesses. Here also having in mind the small businesses with limited resources, and it is a risk that it will be disproportionality, and this can be affected in the discussion of burden of proof rules. So it can be put off financial challenges or disadvantages, just for example, is for smaller entities when having legal disputes. Next slide, please. We are often talking when we are about enforcement issues, and here we have some phrases that we can see as, we say, misconceptions that consumer cannot enforce their rights against large companies. Well, what we can see is that consumers struggle to enforce their rights when dealing with rough traders, which are not compliant by design. But we must have in mind there are a lot of traders outside, and you need to pick the right ones to do the enforcement with. And we also think that when you're talking, there is a need to reverse the burden of proof to allow consumers to enforce their rights. Well, as already mentioned by my colleagues in the panel, that courts have already the possibilities to elevate the burden of proof for consumers. And this kind of reversal of burden of proof that we are discussing here can be extremely difficult to implement on the right levels, and also when we see the differences between member states and how court will interpret the issues. And also the issue that EU lacks an appropriate legislative framework for consumer protection. Well, the important is that we need to allocate the appropriate resources to enforce the rules. There need to be an enforceability, and this is worsened now with the difficulties when you always add new legislation and not having the enforcement issues and problems in mind. Next slide. So what is important now to see is that we need a flexible and clear legal framework. It should be easy to do the right thing for the businesses. So it could enable European businesses to scale up, to protect the omnichannel approach, also to collaborate in the scope to capture the right actors without harming the rule-abiding businesses, and also to recognize the differences between marketing and manipulation. We already heard about the grey zone, and also important to lowering the cost of compliance. And I thank you there.
Yeah, thank you, Yolanda, for presenting your perspective from the point of view of the trader community. In particular, I noted your emphasis on the need for more resources for enforcement. Well, this is a rather long-standing problems that that we need more resources both for the public enforcement but also for consumer associations, of course, to facilitate private enforcement of our legislation. And you also pointed to an important aspect that of rogue traders, so meaning traders who do not have any intention whatsoever to cooperate or even to explain themselves. So yeah, in our work here we also see these two categories of cases. So the one case is about established companies, with whom you can discuss. But on the other hand, also quite many of complaints about companies which have only existed for a short period, and then they disappear, they are gone. And of course, the possibilities for consumer legislation to tackle these cases are somewhat limited. So here we are dealing mostly with the fraud situation that is even more appropriate probably for law enforcement authorities to tackle rather than say consumer protection or authorities. I would like to remind our online audience about the possibility to ask questions or to post comments on this question in the Slido. I do not yet see any comments on the substance, only technical ones about the quality of the stream. I hope it's working well. So please do not hesitate to ask questions. So this is the time we are discussing a rather specific matter with experts in this area, so use this opportunity. But in the meantime, we move then to the next round of questions, and I would now turn again to Ursula, and I would like to ask you to tell us what you think, how we can strengthen the consumer's position in enforcing their rights. Thank you.
Thank you, Martins. And let me maybe also directly say to Yolanda, because you had a slide on the misconception about the problems with enforcing consumer rights. And if I rightly understood, you said that basically there are only problems against rogue traders. And that courts have already the possibility to reverse the burden of proof, which is probably true to a certain extent. But I would say there is maybe some misconceptions on the side of the traders about what are the problems of consumers. Maybe just to then recapitulate, and maybe with my first slide here, please. Under the UCPD, what is the current situation? So as I said in the beginning, we have already an article in the Unfair Commercial Practices Directive that obliges the member states to give the powers to the courts and to the authorities that they are enabled to ask the trader to substantiate the claims that they are doing. So there are several problems, so to speak, with this provision, and why we think it is not good enough. It's not an automatic burden of proof. It lies then in the decision and in the discretion of the court and of the authority. Obviously, there are questions as to the scope, the material scope of this provision, because it's about substantiation of claims. And here, in the examples that we discussed, we are not really probably in the scope of claims. So there may be questions, and there is certainly legal uncertainty about the scope of this provision. And then one argument, I hope that would also be very much convincing to the business community, is that this obviously is a situation where there is big fragmentation between the member states, because in the end it's in the national discretion how this is being applied in relation to the national procedural rules, in relation to the discretion of the judges. From a consumer perspective, this means there is inequality, there is no equality how consumers are treated, how their chances are to obtain their rights and compensation if there are damages. So this is also a question of the single market and the status of harmonization in the single market. I think it is a fundamentally important question here also then, of course, of competition and a level playing field between the different countries and the way traders are positioned. So what is at the core of our demand from a consumer and consumer organizations perspective? We must ensure that the UCPD is enforceable and has also a deterrence effect. And this is why we think a reversal of the burden of proof for unfair commercial practices should become automatic in all the cases where we have these profound asymmetries of knowledge and power, this digital asymmetry that I explained in the beginning. At the very least, also, we could say that if there are circumstances that point to the existence of an unfair practice, so that there is some likeliness, some not normal situation for the consumers, that could be then the trigger for this reversal of the burden of proof. We have also seen from Peter's presentation that there are different types of alleviations that could come into play here, but this is just as a basic approach that we see is necessary. And just to mention one example, which we have in Poland, where there is a broad reversal of the burden of proof in relation to misleading practices, just to show that this is not impossible. We have already countries where this is in place. Next slide, please. Yeah, and we have already heard about the different elements. So we just heard the examples from Belgium about the sales of goods directive, so I don't need to go into the details where the proof of the non-conformity now lies on the trader with a 1-year reversal of the burden of proof, which I have to say from a consumer perspective is still not long enough. We have been advocating since 20 years for a reversal of the burden of proof that is equally long like the legal guarantee period, because for consumers it is very difficult to prove, particularly when you come to the connected products, to the products that have embedded these complex technologies or AI systems, that this is very, very difficult. And we think it was a bit of a missed opportunity now with the repair of goods proposal not also to look into the reversal of the burden of proof, but nevertheless, this is a very good example. And we also have, of course, ongoing the product liability directive, and also I should mention the AI liability directive, where there are different types, again, of alleviations of the burden of proof that are being discussed to ease the situation for consumers. Next slide, please. And maybe the last example that I wanted to provide, can I have the next slide, please? Is the Digital Content and Services Directive, so also sales of goods, where we have also an adaptation in relation to the situation of the consumer, even if it is a one-shot purchase, so to speak, where we have 1 year, or if it is a continuous relationship in a subscription model, for example, where there is a whole time period of the reversal of the burden of proof when during the relationship time when this is ongoing. And maybe just as the last point, I would like to highlight a recital from that directive, which I would like to quote, where the European legislator says that due to the specific nature and the high complexity of digital content, digital services, as well as the traders' better knowledge and access to know-how, technical information, and high-tech assistance, the trader is likely to be in a better position than the consumer to know why the digital content or the service is not supplied, is not in conformity. So this is, I think, in a nutshell, the concept that we think should also be transferred to the unfair commercial practices environment. Thank you very much.
Thank you much, Ursula, for your very concrete suggestions. In fact, yeah, indeed, we have some rules on burden of proof in the UCPD, and you have explained the limits for the effectiveness of that provision. Indeed, only applicable to claims, but not to all types of unfair practices. And on the other hand, we have stricter and more concrete rules on the burden of proof in some of the sectorial legislation, such as regarding the conformity of the goods and digital content and digital services. So yeah, we have quite a few examples to look at and to draw inspiration from. Now I'd like to again turn to Jelle. And for Jelle, we have I would like to ask what more can be done to further enforcement? So maybe looking a bit broader than just the exact question of burden of proof, but in your opinion, what else could be done to further improve enforcement of the consumer legislation. Thank you.
Thank you, Martins. Yeah, as said, we need a whole tool set, and we think another principle. Next slide, please. Another important element for us is on the internet is that it's enormous. We can't check as an enforcement authority every website on the internet. It's technically impossible. So we need to be more resource efficient in our online enforcement. We need to make decisions. And then we think about the principle of compliance by design, which has already been integrated in the GDPR for privacy laws. So if you create a digital system, then you need to integrate privacy by design from the moment of the conception of your system. It's also a new principle of the DSA, of the Digital Services Act. So we think it's also now the moment to integrate it into consumer law. If you create a system, then you need to make sure that it's consumer law compliant. And the current issue for us is that we can only enforce consumer law on the European level on B2C enforcement, which means businesses contracting directly with consumers. But you also have a lot of B2B players in the consumer journey. For example, you have e-commerce platforms, payment providers that are, for example, an e-commerce platform could provide a system to set up a web shop, and it's used by a lot of small SMEs, small companies, to set up the web shops. So as an authority, we can only tackle all the SMEs setting up small web shops. But if the web shop provider is only a B2B player, only supplying business services, business-to-business services, then consumer law does not apply to that e-commerce platform or to that payment provider. So I think the idea should be to allow also the enforcement of consumer law towards these B2B providers when they affect the consumer journey. And also SMEs would benefit from this perspective, because then we would shift the focus from all the small web shops on this system, for example, to the large e-commerce provider, which can more efficiently tackle the system, as they have a huge impact on the consumer journey. So next slide, please. Yeah, some examples where we already used the principle of compliance by design would be some CPC actions of the Consumer Protection Cooperation Network, the European Network of Consumer Authorities, most notably the Shopify case. It's a Canadian e-commerce platform, and we asked it to improve its website templates, which are used by all these small web shops. Often they don't have legal knowledge, these small web shops, the people behind it. So if they are provided with better website templates, and for example now Shopify also provides legal guidance on EU consumer law for them. So that has a bigger impact than going after all the small players. And we also have the case with Visa MasterCard, which now provides subscription information regarding, that was a case on subscription traps, where consumers were suddenly trapped. They thought it was a free trial, but suddenly they have the recurring subscription on the credit card. And now Visa MasterCard provides subscription information on the payment page that requests their credit card's credentials. To avoid going after all the bad players, we go after the payment system to provide information to the consumer, which is more efficient again. And then the final example would be the current of previous playing whack-a-mole with fraudulent websites. We close down a fraudulent fake web shop, and then suddenly another one pops up. So we keep being busy. Now the .be, the Belgian registry for .be domain names, has a new system. If they think there's a possible risk with a new website, they will put it directly in their registrant verification process. So the domain does not get activated. There's no damage for consumers, no potential damage for consumers, and the trader or the fraudster registering the domain would first need to prove his identity. If he persists with, for example, a fake ID, then we still have a notice and takedown protocol. But again, we shift the burden of proof to, in this case, the traders or the fake traders, instead of the authority going after every small case, which gives us the time to go after the real important cases. So.
Thank you. Yeah, I think these were very relevant additions to our discussion. Indeed, in number of cases, we can achieve more if we also work with those who are not directly interacting with the consumers, but who are the infrastructure providers for the traders, because in that way we can address the problem more at the source, and by working with these infrastructure providers, such as the ones who provide the underlying infrastructure for websites, we can probably better ensure that the traders using that infrastructure also respect consumer legislation. It would be interesting to discuss whether they would fall under the compliance by design obligations that are or will be shortly applicable to all intermediaries under the new Digital Services Act. It's an interesting question. If there are any comments on this, would be interesting to hear. And what you said is about the cooperation with domain name registrars is extremely important, because we also see here in the Commission, we see, and then I can only imagine how many complaints on these matters are addressed to national authorities or national consumer associations. We see a lot of complaints about these very short-term companies that get registered under the national domain, collect some prepayments, and then disappear, after a relatively short period and cannot be reached anymore. I see we have a first question on Slido, but before answering that question, for which many thanks, I would still like to conclude this first round of discussion. I'm moving now to Peter, and I would like to ask you, what, in your opinion, could be the modalities of a modified burden of proof in EU consumer law, in particular as regards unfair commercial practices? Thank you.
Thank you. First of all, if I can get my slide. Thanks. First of all, I would like to make a case that there should be a proper rule at all, whatever it looks like. And the reason is, as I explained, in principle, you could do a lot simply by applying the principle of effectiveness. But that principle, or the test of the Court of Justice, is a very flexible one, and therefore a very uncertain one. And not all the national courts are equally observant when it comes to transposing the case law of the Court of Justice in the individual case. So, and in addition to that, I would like to remind you that not all member states have a strong consumer protection authority as Belgium has. But for example, in Germany, consumer protection is done by consumer organizations that are ordinary claimant in civil law civil proceedings. They do not have the power to extract information, check documents and the likes. So they are dependent on what the court offers them. And I had a brief discussion with Yolanda before. We found out that our courts in Sweden and in Germany are very different in obliging traders to disclose information. So what we need is a proper rule that provides legal certainty, that allows claimants to estimate their litigation costs or their litigation risk in the first place. They can't bring a claimant hope that the court will do something, but they must have a proper rule for that. And that's also the issue of a level playing field was already been mentioned. Just a few thoughts on what it could look like. If I can have my... Well, as Ursula already mentioned, of course there must be an indication first that there is something out there, that there is an unfair commercial practice, that something looks strange, that something cannot be explained, to trigger any sort of alleviation of the burden of proof. Then the trader should give a meaningful explanation of the observed phenomenon, not just, as Jelle mentioned before, dump an algorithm on the consumer or the consumer organization or a big pile of paper, but explain it in a way that one can understand it. I borrowed that notion of a meaningful explanation from data protection law, from the GDPR. So if then the trader does not do it, does not provide an explanation, there should be a presumption that the observed phenomenon has been caused by an unfair commercial practice. Otherwise, he would explain it. And of course, as I mentioned before, and as the Court of Justice has already said, a diligent trader does gather and retain evidence or documentation to support their explanations. And when it comes to digital content, they would have it anyway, because it's easy to store that. So, and finally, if then in the end doubts still remain due to technical or to the complexity of the matter, I think the standard proof should be lowered away from total certainty down to some like likelihood of a breach. That's my thoughts on that. Thank you.
Yeah, thank you, Peter, for your suggestion of what could be done. I think we will discuss it afterwards, but before that I still give the floor to Yolanda to complete this second round. And the question is, what would be the consequences, in your opinion, of modifying the current burden of proof requirements for European businesses?
Yes, when we are talking about just the burden of proof, it is a fundamental principle in the legal system to ensure a fair and a just outcome, and modifying these rules could be perceived as undermining the integrity of the legal system, raising concern about fairness and due process. We can also see it maybe can create insensitive for parties to bring, well, not the right claims. If the burden of proof is lower for particular cases or claims, businesses might face an increased risk of baseless lawsuits. And it can also influence the business's approach regarding compliance with law and regulation, because if the burden becomes more onerous, businesses may need to be more cautious and invest more resources in documentation and evidence gathering, more than they do today, even if everybody wants to have good documentation, for example, when the enforcement authority contacts them and provide them. And it can also, in this kind of areas, lead to longer and more expensive legal proceedings as the parties want to meet the new obligations on the requirements that they have. So I think it also can be seen in some of the cases, if you have this kind of trials, that one party believes that the burden has shifted in favor, and this could impact the efficient discussions, that the willingness of parties to have an agreement outside the court. So I think it's really need to have a balanced and fair legal framework to business to see the both sides of this kind of issues. So that is also, and we are all now talking about the product liability directive. And here I think it's important that when they are talking about the relevant evidence that the company have for its disposal. But the fact is that the proposal is not specific of how the notion of relevant should be interpreted. And there we are back what Ursula says, how different countries interpret, how they handle this kind of issues. So I think it's really, that is one of the important questions. But also, if you need to disclose the necessary documentation, it should be balanced against the protection about confidential information and trade secret. That is really important. Having this kind of change, it would have a significant adverse consequences for the industry. So I stop there.
Yeah, thank you, Yolanda. Yes, you put an emphasis on the need for a balanced approach, and certainly if we are to proceed with some changes in this domain, it will be our first and foremost objective to ensure that it is a balanced solution that is favorable, of course, to the consumers for enforcing their rights, but also does not at the same time impact in two negative ways the fundamental rights of businesses such as defense, or would cause kind of too much of administrative burden in order to comply with these requirements. We have now two questions in the Slido, and I would like to discuss those two questions. So thank you for the persons who have asked them. The first question is basically that what about burden of proof in offline world? Is it justified to have a different approach online and offline? In principle, our rules in Unfair Commercial Practices Directive, they are not distinguishing the two scenarios. So very likely, if there is a new rule on burden of proof, it will apply equally to offline and to digital worlds. But I would like to ask you, do you see a need for having different approaches to the offline scenarios. Well, I can easily imagine that even though we talk mostly about the problems of proving the case, proving the unfairness of practice in digital environment, it could be equally difficult also to prove it in an offline environment. So if we speak about, for example, some marketing call, let's take an example. So how can you prove afterwards what happened during that marketing call unless you have been recording that conversation, which is again tricky from the point of view of well, data privacy, for example. So what are your views on this possible distinction between offline and digital worlds, or do we need basically the same rule for both? Thank you. Urso, please.
Yeah, I can start with a first answer. I think we all are aware that the borders between digital and non-digital, between offline and online, they are basically blurred and getting blurred ever more, because if we have now connected products which are equipped by AI systems, if we have like because you mentioned marketing, a telephone call where there is a voice recognition that would then identify your emotional status and would then, provide you with offers that you are then more prone to accept because you are in a specific situation. So is that offline or is that online? I think this is very, very difficult to identify. For us, and that's what I mentioned in the beginning, I think what counts is really what is the situation of the consumer and how is the balance. And as I said in the beginning, we think with this increased use of technology and the possibilities of the technology, we have this asymmetry. We called it the digital asymmetry, but I think it can also be present in the offline world, if we can still call it like that. So I think what really counts is the situation of the consumer, which is that the knowledge, the expertise, and the power to control the processes in which the consumer takes decisions or is informed lies on the trader, much more than in the traditional situation of consumer transactions, and this would then trigger this burden of proof reversal or alleviation.
Thank you. Would you like to comment on this issue of offline versus digital?
Yeah, happy to do so. Well, it's quite natural that some rules have their scope of application. Doorstep selling only applies at doorstep selling situations, and distance selling applies in distance selling. So problems with the website design won't happen in the offline world. But of course, there are other issues where the rules should be the same, and I would just like to mention one where I think that the scope of application is inadequate, which is the obligation to inform about whether personalized pricing is used, as we have it in the Modernization Directive. This is limited to distance selling, but it could also happen in a brick-and-mortar store with Bluetooth technology or whatever, that you could have personalized pricing there, and you should be equally informed about that. So I agree, where the situation applies in the same way in the offline world, the rules should apply to both. Thank you.
And just short intervention, I think, yeah, when the rules are the same, for example, I gave the example of energy labels. When we do a market surveillance of, for example, energy labels, then we will go to brick and mortar stores, and we will go to online shops. We will check both. In most of our market surveillance activities, we will always make a mix of online and offline worlds, where it's applicable, of course.
Yes, well, I can add the same. I think the same rules should apply. What we haven't mentioned today, when I was thinking about, you mentioned business to business, like small businesses and so on, and you are talking about this phone calls to the ones we had working before over 20 years for the consumer side with the agency and the ECC network, and now coming back, it's really giving me new insights how it works, and you have a lot of kind of issues there having the same kind as you raised the ones with the problems that we have. So we need to have a scope also for, I think, the small businesses we were talking in the kind of the issues. There you have also a line to draw. I can start because this happens when we go to the alternative dispute resolution, the ADR. When we have cases there, I'm representing the business side there, exactly that when you said different algorithms, not possible for the consumers there, we have the documentation from the business sides when they have sending in the documents when we decide about the case. So this is already happening, but I think it's really different depending on which kind of ADR, which kind of countries we have, but this is a way we already handle in some countries.
I think it's a very, how should I say? I think it's a good proposal, because it takes also into account the difficulties that you would have if a business, for example, in the field of algorithmic decision-making, AI systems, would just disclose the technical apparatus, so to speak. For a consumer organization, it would be probably on that basis not be possible to understand still what is going on. So you would need another expertise to explain to you what is really behind that technical information that you received. So this idea of giving a meaningful information first, I think it makes a lot of sense. And let me add one point which our Belgian colleague mentioned, and I think it is absolutely central to this discussion, is also how do you make sure that those who deliver the infrastructure to, for example, SMEs who use that, how do you make sure that these people also have their responsibilities and can be held accountable? And there I was really very interested in the proposal that you made, and I think that is something that also in the fitness check should be considered, namely what instruments could you use to not only go to the very end of the chain where you have a business that has no clue about how this works, that the tools that they use, which doesn't mean they should not be liable, but it means that in order to be effective, you probably have to go one step behind and look at what is happening and what do these businesses provide and what is their accountability and what explanations do they have to give. So I think we need to play this on a parallel level, and it's a multi-layered approach that has to be looked at. Thank you.
Yeah, for an enforcement point of view, it can be short, because if there's already an indication of an infringement, then we can ask all useful documents. So we already have this power in enforcement cases. So I think it's mainly a question for consumers or consumer associations going to court.
I can just add that I totally agree with Ursula that you need, because we have, most of our members are the small and medium size, and the bias, you say, from the behind the service, they feel secure that they have bought the right service to have in there, and they have no clue, because as you assume that is happen, and as you say, you need to have backwards the one's way. So I agree on that.
So basically, we should be able to go up the chain and to look for the bigger fish, even. Yes. Yeah. Okay. Mm-hmm. Okay, that's an sure.
I have to say this because we tried that, and we are advocating for this, for example, in the product liability review, where we say also the platforms, the online platforms that are the place where these products that are maybe dangerous, cause damage, that they are sold, they should also, not in the first line, but as a second line, if, for example, the trader cannot be identified, they should also be in the chain which we have in the product liability directive, that if the trader directly, if the manufacturer directly cannot be taken to account, then there are other players in the chain, like the importer, that are held liable. And we have advocated for also the platforms to be in that responsibility chain, unfortunately so far without a lot of success, but it's just another example to show that we need to take into account the economic realities of the market, and those who make profit from offering products or from allowing that products reach consumers, which the intermediaries do, they should also carry their part of responsibility. Thank you.
Perhaps I can take this up for a moment. Well, in the Digital Services Act, we already have a tendency towards that sort of role of the platforms. Well, if they are supposed not to design the platform, or they're supposed to design the platform in such a way that traders can comply with their obligations. So even more, they shouldn't design their platforms in such a way that the traders cannot comply with their obligations to inform. So it's just another step in that direction, I think. It's in the logic of platform regulation.
Yeah, indeed, the DSA is obviously a major step forward, and it addresses many issues, but it applies to intermediaries, so it applies to intermediary service providers. So as I understand, we were also looking and discussing the situation of infrastructure providers who are not necessarily intermediary service providers in the legal sense, right? Yeah, so in this respect, that would be a novelty if we were to consider how we can address these B2B players, essentially, who are only providing infrastructure for the traders who then use it in order to market products to the consumers. So we are still welcoming questions. We still have a couple of minutes left for this panel. I see there is a question. It's not on the subject of burden of proof. It's on the pledge. So it's a question about which commitments under the new pledge go further what is already mandatory under the DSA. So the simple answer to this question is that the new consumer rights commitments that the 11 marketplaces signed here today are not, they are related to the DSA, but they do not duplicate or they do not overlap with any of the DSA obligations. So, for example, if you look at the rather detailed commitments on the fairness of consumer reviews, you will see that there is nothing in the commitments as regards the removal of fake reviews, removal of illegal content on the basis of a notice. So on purpose, we didn't tackle such questions in the pledge, which are already addressed in quite a detail in the DSA. And you see that the commitments, they go beyond the current requirements of the platforms. For example, in the consumer laws, there is nothing about how platforms deal with their influencers in a B2B context, basically. So platforms now commit to also to educate and to include in their contracts with the influencers an obligation for those influencers to be transparent towards consumer in their marketing work. So platforms are committing to educate more generally their traders, sellers on consumer law. So these commitments, they are of course related broadly to the consumer legislation and to the DSA, but they are not copying or duplicating any of the existing rules. I do not see any other questions in Slido, so I think we can move to conclude this session. And I would like to ask for a final round of short comments, short concluding comments from every expert on the question. So what needs to be changed or improved? Please, can I ask you also?
Yeah, I think I said it already in the very beginning. Because of the principle of effectiveness, I really can only repeat that the burden of proof adaptations that we think are necessary, that they are really something that we hope the Commission will put at the core of the fitness check, because the exercise of rights is what matters in the end to consumers. And this is exactly the weakness, I think, that we have in Europe. I think, Yolanda, you started to say that Europe has the best consumer rights in the world. We don't have the best enforcement system, and we don't have the best compliance. I would say, like the last fitness check showed that this is a big issue here. And so this is why we need to adapt and we need to improve. We have heard a number of solutions. I think all of them are relevant. Maybe just on a horizontal level, I would also like to repeat that it would be necessary to not only look at the enforcement steps and at the courts and the public authorities and how they could have more possibilities if there is a likeliness, if there is an indication to alleviate the burden of proof, but that we should also look at compliance, and we should look at the infrastructure, and we should hold other players in the chain responsible. Otherwise, I think, as our Belgian colleague, I think very clearly illustrated, enforcement authorities will not be able to do the job. We need to look at compliance from the scratch, if I can put it like that, and we need to have a better system in making the chain accountable. Thank you.
Yeah, as mentioned, I think compliance by design could make the work of enforcement authorities more efficient, more resource efficient, and it would benefit both consumers, enforcement authorities, and also small traders. So for us it's a win for all parties. Yeah.
Well, I fully support that. I would say legal certainty is one big issue. Whatever the rule is, it should be pretty clear. It should be predictable for claimants what happens. And I think you mentioned compliance by design. I would make a point in favor of standardization. There are simply certain issues that do not need to be in the liberty of website designers, but that should have a simple, clear rule that everybody has to obey to. And then you don't need to go through years and years of litigation to find out whether this particular design is compliant with the general rule, but you have just one, like a cookie banner, which has to look like this full stop. Thank you.
Yes, now everything is taken, but I think legal certainty is really important. It should be easy for businesses to do the right thing. We have struggles with the new legislation coming and they to learn and all the updates, and I think we should evaluate the fitness check and to see what are the results, what are the hurdles or the problems before we come with new legislation. So, and finally also a dialogue between enforcement authorities and the business side, because that is really helping to educate, to have misinterpretations over everything. So I stop there. Thank you.
Yeah, thank you, Yolanda, and I would like to conclude now by thanking all of the 4 experts here for your contributions. What you said has been very, very interesting and informative, certainly useful for our work in completing the fitness check, which is expected around June next year. And I also hope it was interesting for you and for our online audience. So it's about time to conclude. Thank you for your attention.
Thank you.